May it please the court, I'm John Chandler of the Hamilton County Bar. I represent Rex Sullivan individually and as the administrator ad litem for his now deceased wife, Rose Sullivan. I ask the court to let me reserve 5 minutes of my time for rebuttal.
That'll be fine.
Your Honors, I'm not going to discuss the facts of the case unless you have any questions about them. I think it is overwhelming evidence, both direct and circumstantial evidence, that the Carden defendants deposited the patch of mud that caused Mr. Sullivan's wreck and injuries. First thing I'd like to address is that trial court's ruling was kind of interesting in that the court said that mud is a naturally occurring substance, frequently deposited on rural roads, and virtually impossible to clean up, and that it's not inherently dangerous substance. Although all of those things are true, that doesn't mean that a large patch of frozen mud can, and in fact did, cause Mr. Sullivan's wreck and his serious injuries. And it also doesn't mean that the Carden defendants didn't have both common law and statutory duties to remove that mud, or at least make a good faith effort to do so before Mr. Sullivan's wreck. The trial court emphasized that there was no water source. So for that reason, it would be impossible or virtually impossible to remove the mud. However, in several of the cases that were cited to the court in my brief, including one of the cases, they used shovels. 2 men with shovels, 2 hours, paying them $25 an hour, $100 could have probably removed the mud sufficiently to prevent Mr. Sullivan's wreck. Because they didn't even attempt to remove the mud, he had a wreck, incurred serious injuries, and incurred medical expenses over $150,000. It's not too much to ask a person to deposit mud on a rural road or an urban road to at least make an effort to clean it up before it causes a foreseeable wreck.
Counsel, the proof here in this record that Mr. Carden and Carden Trucking left the mud on the road comes from the neighbor. Is that the only evidence that this mud that was deposited on the roadway was from Carden?
Well, of course, you've got the physical, the fact that it physically is at the end of the partially gravel road that was the access road into the extraordinarily muddy 35-acre tract that they had been logging for the 4 or 5 days prior to that, and during which time they had hauled 2,700 tons of timber on tractors, on log trucks. And then the day before Thanksgiving, I believe it was 2 days before the wreck, they had hauled the equipment, these huge bunchers and binders and so forth. You know, these are huge pieces of logging equipment that were going through this huge mud. And they put them on lowboy trailers and hauled them out onto Liberty Hill Road. There is no evidence there was any other logging operations being taken place on Liberty Hill Road. There's absolutely no evidence whatsoever.
Was there any evidence that anybody else was coming out that gravel road other than the logging folks?
Absolutely not, Your Honor. I mean, this is into the logging, this is into the parcel. There's no reason for anybody to drive down this partially gravel road to a logging track unless they have some business there. And then, of course, we have the neighbor, Jackie Sullivan, who's an extraordinarily impressive witness, who said that he drove by there several times. His farm is so close to the access road that he could see it from the gate to his farm. And he drove by there several times in the days prior to the wreck and said he saw mud streaming out onto Liberty Hill Road from that access road. And he actually saw the day before Mr. Sullivan's wreck, a woman almost have a wreck when she slid on that mud. And another thing on top of it all is, of course, this was Thanksgiving Day. The mud was not only packed, large patch, but it was also frozen. So it was even more dangerous under those circumstances, which could have reasonably been assumed or expected by the Carden defendants when they deposited it there and left it there.
What was the proof before the court as to how much mud? I mean, I know there's photos in there, but what
Your
proof
Honor,
was presented?
that's one of the things, I'm glad you asked me about that. I finally, in volume 10 of the technical record, got some color photographs that were made by Mr. Sullivan, by the neighbor, Jackie Smith, the afternoon of the wreck. And fortunately, they're not great photographs, but they show the patch of mud we're talking about and its location relative to the partially graveled access road. And, Your Honor, the question really is one for the jury. Should the Carden defendants have reasonably anticipated that this volume or this size patch of mud could cause a wreck and clean that mud up, or at least attempt to clean it up with shovels if they didn't have access to water? In addition, and of course we have a Tennessee case, it's a 1936 case, it's the Radnor case, and in that case, the water company was digging a ditch to put in a pipe next to a roadway. They put the mud or dirt on the road. They attempted to clean it up with shovels, but apparently they didn't do a very good job because it caused a wreck, and the court held or allowed it to go to a jury, and the jury found for the plaintiff that the defendant water company should have reasonably anticipated, that this could cause a wreck and had a duty to clean that up, and it was a common law duty. These are jury issues, Your Honor, about whether they had a duty, whether it was foreseeable that this could cause a wreck.
Not whether they had a duty. I mean, that's a conclusion of law for
You're
the
right, Your
court
Honor,
to decide.
but with that case, I submit that there is a common law duty. In addition to the common law duty, we've got the Tennessee statute, TCA 558170. That statute lists several items that must be removed from a roadway. All of those items are things like glass, wire, things of that nature that are unnatural objects. There's no Tennessee case, and there's very few, I don't know if there were any other than the Arkansas case I cited, that address the issue of whether that statute includes natural objects such as mud, gravel, things of that nature. But the language of the statute, it lists the unnatural objects, glass and so forth, but then it also at the end says, and any other substance likely to injure. It doesn't say any other similar substance, any other unnatural substance. It says any other substance likely to injure. And in the Arkansas McKim case, that was a 2019 case, they have the identical statute as the Tennessee statute, and they interpreted it to include natural objects as well as unnatural objects. And I certainly understand that's not binding, but I think it's persuasive authority that the Tennessee statute should also be interpreted in that fashion. There was also an issue raised about Ray County's responsibility for cleaning the mud up. But, Your Honor, there's no evidence in the record whatsoever that Ray County had any constructive or actual notice of this mud situation, which is required for them to be liable under the GTLA. And the only evidence we have of any notice they received was 6 days after the wreck, after Mr. Sullivan got out of the hospital, he called the Ray County Highway Department, reported his wreck and the situation at the location of that wreck. And I believe that's all I need right now, Your Honor.
You have your time for rebuttal. We'll hear from the appellee.
Good morning, Your Honors. Michael Petherick here on behalf of the defendant in this matter, James Carden. He was sued as an individual and in his capacity as the owner of James Carden Trucking. Now, this appeal really boils down to one issue, and that's whether some mud that was tracked onto a country road in a rural area by common agricultural activities that take place almost every day there gives rise to a duty that warrants either warning of its existence or removing it from the road. The trial court concluded that it didn't give rise to a duty under these facts and circumstances, and we respectfully contend that the trial court did not err in its ruling.
And that's a question of law.
Yes, Your
So
Honor.
we
Duty
look at it
is,
just de
it's a
novo.
question of law for the court to decide, and you anticipated an argument of Mr. Chandler's that I was going to address. Now, Mr. Chandler already addressed a lot of the relevant facts at issue. I'm not going to go into too much detail, but obviously this wreck occurred on Liberty Hill Road, which is in Evansville, Tennessee. It's in Ray County. With all due respect to the residents of Evansville, I think that no one would dispute that it is a very rural area. The area, particularly right here around Liberty Hill Road, there's not a whole lot going on around there. You do have some residences, but a lot of what's going on is common agricultural activities such as farming, some other activities like hunting, and as is at issue in this case, logging. In respect to hunting, the plaintiff himself was on the way to go hunting when this wreck occurred. Now, early in the morning after Thanksgiving in 2018, the plaintiff got in a wreck and flipped his car. That's undisputed. It happened, and he was severely injured from that. Now, although the plaintiff doesn't exactly know what caused his car to lose control, he's alleged that it was mud on the road, and that obviously my client's logging activities that took place in November 2018 caused that. The proof in the record, it's undisputed by the parties. It shows that my client was logging at a site for Resolute between November 13th and likely November 21st, 2018. So as an initial matter, those activities stopped 2 days before this wreck even occurred. You're not going to get any dispute as to the time frame for that. That being said, we contend that there wasn't sufficient proof beyond speculation to even show that my client caused mud to be on the road.
Counsel, I mean, this went off on summary judgment, correct?
Yes, Your Honor.
And you're saying there's no genuine issue as to whether or not the mud came from your client's operation?
Well, Your Honor, I argued that in the trial court. I also raised an alternative argument, which was that alternatively, even if the plaintiff could prove that there was mud that was deposited by my client, that there was no duty.
All right, and the trial court went on the second basis.
Yes, Your Honor, and you're actually anticipating.
Your client, there was no duty, correct?
Yes, Your Honor. Under the standard in Rye, the trial court assumed that particular fact in favor of the plaintiff, assumed that even if, that they could prove it, but that even if they could prove that there was no duty that existed. Now, we contend that there are some good reasons which support the trial court's conclusion. As the trial court noted, mud isn't necessarily of itself an unreasonably dangerous condition. It's naturally existing. It exists all over the place. It comes up whenever there's rain. To rule that mud is an inherently dangerous condition would impose a massive duty on all landowners in the state of Tennessee.
But is that true for all levels of mud? I mean, what about mud that covered a roadway, say an inch thick? Would that create a duty?
I think it depends on the facts and circumstances. I think that I can't conclusively say that there is no situation where, some amount of mud could not be an unreasonably dangerous condition. And depending on where it is, that could potentially give rise to a duty. So I guess it's more of whether, under these specific facts and circumstances, the location of the roadway, the activities that go on there frequently, and the amount of mud on the road, whether that actually gives rise to a duty. Now, the trial court noted in its ruling, and I would emphasize once again that the area where this wreck occurred is extremely rural, and agricultural activities occurring up and down it are extremely common. Mr. Smith, whose testimony has already been referenced, he testified extensively about being aware of logging activities going along there. He himself was driving a four-wheeler that he had just taken onto his own farming land. It's undisputed that there are a lot of different vehicles that drive up and down this road, and that there are actually multiple logging sites along it. My client actually went to a different logging site several miles down.
Was there proof in the record that there was, at the time this accident occurred, the mud was deposited, that there were other active logging sites?
Your
I
Honor,
understood opposing counsel to say no, there wasn't.
agreed. And I would contend that currently in the trial court record, as of this specific period of time, the only logging site that I am aware of, based on the testimony of the parties that was active, was this particular logging site. Although I would add that that doesn't mean that there weren't vehicles accessing other properties. Obviously, we've already talked about Mr. Smith. He was obviously driving a truck and a four-wheeler on and off of his property. There are other farms and residences along that road that could also potentially track mud around.
But what farming operation would be going on in November?
Likely not a lot. So in terms of farming, there probably wasn't much of that going on at this particular time. As I said, there are logging sites. Depending on the period of time and the location of the roadway, they could be there, although, as we already discussed, there's only evidence of this one on this particular property at this period of time.
Or on this road?
Yeah.
Active logging sites at this time on this road?
Of which I am aware of, and obviously...
It's in the proof.
Correct.
Okay.
Correct, Your Honor. But in addition, obviously, we already discussed farming not being a likely option at that time. Logging is a potential option. As I mentioned, there are people who do a lot of recreational activities like hunting, as the plaintiff and Mr. Smith were on their way to do.
But none of that was the basis for the trial court's decision. Trial court, as I understood what you said earlier, the trial court said, okay, I'm going to accept at least there's a genuine issue here at this time that the mud was deposited from the defendant's operation.
Correct, Your Honor, and we already discussed that.
Now, I want to ask you then on that.
And I can move on from those facts, which we may have argued in the trial court, but that the trial court ultimately...
Now, I want to talk about what the trial court found. It found that did not have a duty to remove the mud from the road, and that creating a duty, said opposing, but to clean the mud off the road or to clean the vehicle before they enter the highway would be unduly burdensome and virtually impossible, and are practical to impose upon trucks. What proof did he have that was so?
Well, Your Honor, I think he could take notice. He was familiar with the area where this occurred, and the proof in the record showed that it was a very rural area.
No dispute, it's a very rural area. I grew up in Loudoun County a long time ago, but it was about as rural as you could get.
Yes.
So I understand the trial court's stand on this. But what proof did he have that it would be unduly burdensome to clean the mud off? Maybe not get the road spotless, but clean the mud
Yes,
off.
Your Honor. And I think, once again, and I don't want to beat a dead horse here, referencing multiple factors. Obviously, it's a pretty rural area. I mean, there are ways potentially that mud could be removed from a roadway. I guess
Like if it's deep enough, you could shovel it off.
Correct, Your Honor. It is possible. But I guess looking at multiple factors, obviously for foreseeability, you have the question of what is the risk that's coming from the condition versus the burden imposed on the person to remove it.
And again, what was the proof that the trial court had that it would be unduly burdensome to clean the mud off?
Well, Your Honor, I think it's a legal conclusion, really.
I understand, but what was the basis for him coming to that legal conclusion?
I think it was the proof in the record as to the area where this occurred. As I said before, it being a rural area.
He talks, I understand it's a rural area, but he talks about they'd have to pull their vehicles to the edge of the road, wash it off with a water hose, pull it back right on the road, get a hose, access. He talks about washing it off, but I don't see that he ever says anything about any proof presented to him that there were no other method available to him, like a shovel.
And, Your Honor, respectfully, I think I get what you're getting at, and I think it may have been the trial court taking perhaps his knowledge of the area where this occurred and taking judicial notice of it.
Okay, let me ask you, if you could probably take judicial notice, they could find a shovel someplace. But if a log had rolled off one of your client's trucks onto the road, would you agree that there'd be a legal duty to do something about that, to warn motorists or to remove it from the road?
I think it would depend on the area of the road where it is, the area where it occurred.
Okay, on this road, at this spot, a log rolls off the truck and rolls on there onto the road. Is it your position that your client has no legal duty to either warn motorists or to remove the log?
No, Your Honor, I'm not taking that position.
So.
And I can represent to the court that if there were, let's say, a log came off of my client's truck, as Your Honor stated, fell into the middle of the road, I think that could give rise to a common law duty and potentially even a statutory duty under that TCA section that Mr. Chandler was referencing. Yeah. So it kind of depends on what the condition is, as well as those other factors that we've already discussed at length. And that brings me into another point that I'd like to make, and it's the arguments that are being raised by the appellant about that TCA section. It's 55-8-170. It prohibits people from leaving, and I quote, destructive or injurious substances on the road or any other substances that are likely to cause an injury. Now, with that hypothetical that's raised, about a log being placed in the middle of the road, I think both under common law and under this statute, that would apply. Now, what this statute is doing is it's codifying and criminalizing that particular activity. Under these circumstances, we contend that mud is not a destructive or injurious substance, or that it's likely to cause an injury under these particular facts and circumstances. Now, with regard to a couple of arguments raised by the appellant that I'd like to address, the first is that their argument that the trial court even ever expressly ruled that naturally occurring substances, which is the language that was used in that Arkansas case construing their statute, was cited. We contend that ruling never even took place. The trial court obviously referenced that mud is a naturally occurring substance, and that activities such as logging in these areas are very natural also, but they never expressly made that ruling. And as we've already hashed out in our briefs, and I'll leave that argument to the brief, we think that case from Arkansas is distinguishable based on the trial court's ruling, and obviously it would only be persuasive authority, and it's not binding on this court. So to summarize, Your Honors.
Counsel, excuse me. Let me take you back to a question that Judge McBrayer asked. Doesn't it kind of turn on how much mud we're talking about? I mean, a couple of clods of dirt or mud, might not be dangerous. 2 feet of mud dropped on obviously would be. So somewhere in there, so isn't it dependent upon some extent to at least the amount of mud we're talking about?
Yes, Your Honor, and I think we've already discussed this, but I think it's definitely dependent upon the amount of the substance. You know, it's not just that any naturally occurring substance can't be a dangerous condition. It's just based on how much of it, where it is, and the other facts and circumstances at issue. So with that, I see my time has run out, so I'll pass it over.
We'll hear from the appellant rebuttal.
Yeah, the one thing I find really distressing, I live in the country. I've lived on a farm for the last 20 years. I've got a tractor. I drive up and down the little country road in front of my house, and my neighbors do the same thing. And I see occasional clods of mud out in the road that aren't dangerous, but this is not that situation. Once again, it depends, as the court indicated, the amount of mud we're talking about. If it's a patch of mud the size of the patch that they left, that can cause a wreck. It almost caused a wreck the day before per Jackie Smith when a woman slid on it, and it caused Mr. Sullivan's wreck the day after that. It's enough mud, they should have used shovels to try to get it off. And I don't believe there's any reasonable basis to distinguish between the legal rights of rural residents vis-a-vis natural substances on the road than urban residents. They don't have any lesser rights. If somebody drops a large rock in the middle of a rural road that causes an accident and injuries, they should be held liable. If they do it on the city street, they should be held liable. There shouldn't be any difference in the legal rights of Tennessee residents just because they are rural residents. Obviously, mud is not inherently dangerous. We're not claiming that it is. But if it's sufficient quantity to cause a wreck, it is inherently dangerous. It is dangerous and should have been removed. And of course, as the court pointed out, natural objects include not only mud, gravel, sand, large rocks, timber, crude oil that could cause wrecks, and that should be removed if they are spilled in sufficient quantities to cause a wreck. And that would be foreseeable to the Carden defendants or anybody else. And the statute, once again, the Arkansas decision in the McKim case is not binding in any way on this court, but it is reasonable interpretation of the same statute that we have in Tennessee, TCA 558170, because it contains the catch-all language after the list of unnatural objects like glass and wire and so forth. It says, quote, any other substance likely to injure. Mud in sufficient quantities, as the quantities that the Carden defendants left on Liberty Hill Road, is another substance likely to injure. So I respectfully submit that this court should adopt the same reasoning in holding that that statute applies in this case as well. Thank you, Your Honor.
We appreciate your oral argument this morning and your briefs.